Hey everybody, it is Andy Reynolds. I am here with Frank Yoswick, our Director of Estate Planning and Tax here at Ballast. And thank you all for joining our webinar today. So we're going to take a little bit of time to talk about a question that we get a lot, and something we talk to people a lot about a lot proactively. And that being, should I have a trust? Should my estate plan be comprised of a trust? And if so, is that good, bad, or indifferent? So, just to jump into things, Frank, do you want to just jump into the simplest question? What is a trust?
Yeah, sure, absolutely. So, a trust is a legal agreement between a grantor, the person who puts money or property into a trust, and a trustee, the person who manages the money or property. And then there's typically a beneficiary that could be the same person or a different person, and that's who, for whose benefit the trustee manages the trust property. So you can get a whole lot more complicated from there, but Andy, at the very basic level, it's just a legal agreement between someone putting money into a trust and then a trustee to manage it.
Yeah, and I think like big picture, I think a lot of times people wonder, okay, these trusts seems awfully complicated and whatnot, but effectively it's a document that governs an account, right? Or governs some assets and what can be done with those assets and give certain permissions to people. And I think a lot of people get overwhelmed with trust because they think of, you know, super ultra high net worth people and families who have all these trusts and things are owned by trusts. And a lot of times they're just confused because of lack of understanding of them. And then when you do get your trust document, it's 50 pages long with a lot of what ifs and if thens
Yep.
and and backup professionals and backup fiduciaries with inside the trust. So, a lot of trust can be done to accomplish a lot of different things, right? So,
Yeah.
um,
I say part of the benefit and the trouble with trust is pretty much as a kind of a general rule, anything that is legal, you can do in a trust. So to your point earlier, you think about it as a rule book for what can be done with these assets that are in trust. And if you have an idea and that is a legal idea, you can have that be in the trust. So that's where you can really start stacking up the thickness of the document. If this happens, then this is the situation. But if that happens, well, then that's the situation. And you can really go as in depth as you want to go. And I think as well, Andy, that's where a lot of people, one, reading the document, that's where it can get confusing. But then also the formation in the beginning, just getting started can almost be overwhelming because of the different possibilities and the various things that you can do with a trust. It can be a little daunting to go ahead and get that process started.
For sure, for sure. Talk a little bit about the different. Obviously, there's a lot of different ways, but there are typically some very normal reasons why people would want to set up a trust and certain different types of trusts.
Yeah.
We can get pretty complicated and into the weeds on that, but today, trying to stay high level, talk about what we typically see, or when we're seeing a situation, what situations we typically bring up the idea of a trust to families.
Right. So again, to your point earlier, a lot of people think of a trust as having to be for ultra high net worth families, and yes, that is true. But what we see more common is just the husband and wife who have a new baby or young kids to some extent, under 18 years old. And really, what we see there is you can just do a simple trust document that effectively lays out the rule book. Should the worst happen to mom and dad, kids are under 18, assets funnel into this trust. Absent the trust, assets would funnel into a custodial account for the kids. The day they turn 18, happy birthday. Here's all the money that you can go do whatever you want with. May not be the best outcome available. So a trust really kind of just puts some structure and some rules around what can happen with that money. How does the trustee spend it? How can the beneficiaries access it? When can they access it, et cetera? So it really, the most common that we're seeing is young families with young children being under 18 is a perfect situation for a trust. And that is not necessarily your ultra high net worth family by any means.
Yeah, I think that's definitely a common scenario. I think also, spendthrift provisions.
Okay.
So you do have an older child, maybe an adult child who is prone to maybe spending more than they should, maybe not financially responsible, or as financially responsible as you would hope that they would be. So spendthrift provisions, obviously, as well, divorce provisions. Special needs is always a big topic for trust planning. Um,
Yeah.
we've done a handful of those and worked with some attorneys in town where you may have the child who just is unable to manage their own needs, and there's lots of formal rules around special
Right.
needs planning, which is a big part of it. Medicaid planning, which is pitched a lot. It takes a really certain situation, in my opinion, to want to do Medicaid planning. And then, as you're saying, putting the rules around it, but also the liability protection.
Hmm.
Ultimately, the benefit of a trust is if I inherit the money, mom and dad, they pass away, I inherit the money, I put it in my own account. Well, now that's my asset.
Right.
If I inherit it in trust, well, now I say, whoa, 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 wait a minute. I T-bone somebody, was thinking about work, not paying attention, have a car accident, and it's a bad accident. I can have the defense of no, actually, those aren't my assets. And legally they're not. They're under a
Right.
different tax code. And that there's the protection of that for whether it's, just general life. Maybe it's somebody who lives in or works in an area where high probability of being sued. We say with physicians, it's not
Right.
if, it's when. When are you going to be sued?
That's
So,
right.
there are a lot of areas where I think that can really step in, and with definitely one of the most common is young kids. They just are not able. You have all this life insurance money, you're building an estate. They're not able to step in and handle their own assets. And hopefully someday they are.
Right. Yeah. And that's where the trust is the perfect vehicle for that. And a lot of times what we'll see is provisions built into a trust so that, when the kid is young, the trustee has the discretion to make distributions for health, education, maintenance, and support. That's pretty standard language. And then a lot of times what we see is as the children get older, you build in provisions into the trust. So, for example, at age 25, they can take 25% of the trust principal out, go do whatever they want with it, hopefully not make bad decisions, but maybe there's a good likelihood they'll go make a dumb decision with the first quarter of the trust assets. But big picture, it's only a quarter of the trust assets. Then at age 30, they get a little bit more. At age 35, maybe they get the whole thing. So this kind of eases them into, hey, here's a big amount of money. Try not to do something dumb, but we were all kids once. But then as you get a little bit older, a little bit more mature with your life and your finances, hopefully by that point, if your trust is structured that way, then the children are, grown adults at that point, ready and mature enough to handle their own finances. And that can also kind of self unwind the trust as well. So it's not necessarily, doesn't have to be there in perpetuity. But that's a common provision as well for getting into a trust and getting out of a trust.
Yeah. And I did want to add in this of where the trust might fit for somebody in different situations. Obviously, there's a net worth at which trusts help a lot.
For sure.
And so, what we've started to see, I think, in our practice is a level of wealth where it may involve a corporate trustee. So, hey, we have some complex situations going on. Maybe we have some businesses. Maybe we have some complex investment assets. Maybe we have IRAs that we just our kids don't want to deal with, and we have the ability to put things into a trust where we can then hire a independent third party trustee, where that trustee can then step in and manage those assets on the behalf of children or whoever the next generation, whoever inherits the money. I think we've seen that become more and more popular. There's we did a video before with a independent trust company who we work a lot with, and I think there's a degree of wealth. Maybe it's $10 million per beneficiary or above that, where they can say, hey, look, I'm getting the income that I need off of this trust, and I don't want to deal with everything else. I don't want to do the tax returns. I don't want to do the investments. I don't want to have to worry about that. I've accumulated a wealth level to where we just we just want to live life and use the assets that mom and dad or aunt and uncle or grandma and grandpa left for us. So we're seeing that become very popular in the industry right now, where these third party trust companies are popping up, and it's a bifurcated agreement where advisors like us can continue to work with the next generation or even with the original Gen 1, and we are able to then bring in a trust company at some point in life where, maybe Gen 1 doesn't want to or have the capacity to handle their affairs anymore. And the level of wealth can justify a lower fee and a reasonable fee for a trust company to step in and manage a group of assets. And obviously, a trust company is a fiduciary, so it would have to be, doesn't have to, but it would make sense to wrap up that relationship in a trust where Generation 1 can set the parameters of how that is to be done, as you mentioned earlier, Frank.
Yeah, and I think one of the things you said in there is a really great point that is often overlooked. When you have a trust and it becomes irrevocable, so let's assume during life, mom and dad set up a revocable trust, mom and dad die, now that's an irrevocable trust. That has to file its own tax return, and it's the trustee's responsibility to do it. So I don't know too many people that I've met in my life that really enjoy filling out tax returns and preparing them and whatnot. When you're adding a layer of complexity of doing a trust tax return and the trust accounting that goes along with it, great reason to have a corporate trustee. You mentioned the level of assets in the trust. Obviously, you do want to have a substantial enough level of assets to where it makes sense to cover the trustee's fees and you're not eating up all the principal just paying the trustee to do the work. But I think another thing that is a good reason to have or to think about having a corporate trustee is family dynamic. Let's say you've got two kids that are more than one child, and they don't all necessarily get along. And if one of them is more responsible than the others, well, that's the obvious choice that one's going to be the trustee. But okay, wait a minute. Now you've got brother having to go into sister or sister having to go to brother every time they want money. And it can just kind of create a rift in there that might not really be the necessary thing. That might not want be the legacy that mom and dad want to leave to create for their children. So in a situation like that as well, a corporate trustee stepping in and being kind of that independent referee to, hey, don't come to me, sibling, go to the corporate trustee, and they're the leader of the rule book, if you will. They're going to be the ones that'll give you the money or not, based on the parameters set forth in the document. But I think that great reasons to have a corporate trustee. Can add a little bit of layer of complexity, and obviously is going to come with a fee as well for their services. But can be very good reasons to have them.
Obviously, there is a degree of wealth where we're back talking about estate tax.
Mm,
Estate tax has gone up considerably. Now we're looking at around $30 million for a house for a couple,
right,
where we have to worry about estate tax. So, it's certainly something that we think about and getting assets outside of an estate
right.
for appreciation. But certainly has significantly decreased the amount of people. There's a time where it's a million. There's a time not that long ago when it was 600,000. And attorneys were dealing with estate tax for a big percentage of the population. Now at 30 million, it definitely covers a lot less people. But if you're in that range where you have a family business, you have securities, you've inherited money, um, utilizing a trust to have appreciation outside of your estate obviously is really beneficial as well. Talk.
Just key on that real quick as well. There's no free lunch, right, Andy? So you get the assets out of the estate, you get that appreciation growing outside the estate. That is a great thing for estate tax purposes. But if you put assets into a irrevocable trust and then you die, you lose out on the benefit of the basis step up, which you would otherwise get, right? So you buy a security today, it grows for the next rest of your life, and then you die and you own that asset in your life, it will get a step up in basis. But if that's in an irrevocable trust, you lose out. So you got to make sure that what you're doing is going to end up being ultimately tax beneficial for your next generation or whoever the beneficiary is.
Yeah, that's a good point. And so I want to talk about charity and utilizing trust for that, but
Absolutely.
let's kind of go to where you're going. Let's talk about the downsides of trusts.
Yeah.
So, it is not a free lunch. So you mentioned a lack of a step up in basis. So when
Right.
someone passes away, you get a step up in your cost basis on that asset, most assets. And when it's in an irrevocable trust, as we said earlier, it's outside of your state. So you don't own it anymore. So you
Hmm.
don't get the step up in basis any longer. Some trusts were able to finagle that a little bit. But generally, if we think about an irrevocable trust, it can't be changed. Probably don't get a step up in basis in that. Talk,
Yeah.
trusts aren't perfect, right?
Right.
We've had situations where maybe it was a relatively simple scenario, and because it did involve a trust, it got a little bit overcomplicated, and things could have been done a lot easier. Talk a little bit about the downsides of the trust that you've seen and we've seen.
I think you get into a situation where a trust can be the great tool. It can also just overcomplicate things. If you're in a situation where you've got two grown children or whatever, a number of grown children, they're relatively financially responsible. You're not looking at an estate tax consequence for the level of net worth. Maybe you don't need a trust. It does add that extra layer of complication. We got to get an attorney to read this document, figure out how all the assets flow. We got to open up trust accounts. We got to file trust tax returns, et cetera. That can really be just a little extra and not more negatives than positives coming out of that situation. So I think there is a situation in life where you're just getting started with your family, you have young kids, trust makes perfect sense. You fast forward 20, 30 years down the road, maybe you don't need it anymore. Maybe you go in and just revoke that trust and never funded it in the first place. So if you're using a pour over will technique, which is maybe getting into the weeds a little bit, but you can just kind of back out of that trust at that point. So I think there is a life cycle where it makes sense to have a trust, and then some time passes, and for that same exact family, it doesn't make sense anymore down the road.
Yeah, I think, the state plan attorneys, and when we're talking about this, we use the term controlling it from the grave. Sometimes control is good. Sometimes control can like I said, just overcomplicate or put too many strings in, and now all of a sudden our team that we felt was pretty tight. Now, all of a sudden, we're having to bring in the attorney again and saying, "Hey, what did this document mean?"
That's right.
Or, the other thing is tax consequences. There's no free lunch. So, yes, there are some tax benefits to trusts, but
That's right.
income wise, we can get some income out of the trust, but some income we can't get out of the trust.
That's
And
right.
trusts, irrevocable trusts are going to pay a little bit more income, get to a higher income tax quicker. So, it's not there are some downsides to that trust. IRAs, Secure Act changed the way IRAs are handled. So if you haven't looked at that in your trust documents since Secure Act 2020, 2022, then it's something that needs to be revisited. So
Yeah.
big picture, we're generally advocates of trust, I think, in the general sense. Like I have a trust for my kids, you have a trust for your kids.
Yep.
Definitely with the young children makes sense. As life goes by, I think just to your comment, it may make sense for a family at some point, but take a step back and just continue to evaluate it because it's not all good. There are some negatives. And sometimes when you write, believe it or not, when you write a 50-page document, something may not go as expected. And all of a sudden you end up with, oh shoot, that's not what we intended, but now it's in a document and I didn't think of every single possible outcome. And attorneys do a good job of trying to write it in a way where you can cover a lot, but every once in a while you stroke the pen a little too tightly and you overlook something or you unintentionally hinder things as well. So it's just
Yeah.
something to think about. No free lunch. I think that's a good way to say that. Frank, talk just a little bit about charitable opportunities for trusts. We've covered so much. There's so many different
Yeah.
things about trusts. Talk a little bit about the charitable side.
Yeah, so there's a lot of different things you can do charitably with trusts. You can, some of the most common that we'll see is charitable remainder trusts. And what this is basically the charity gets the remainder of the assets. So trustee or grantor puts assets into the trust. There's a calculation that will determine, kind of estimate what the value of that asset will be at the end of the grantor's life. So in year one, when they put that asset into the trust, they get a tax deduction for that estimated value at the end. And then during the grantor's lifetime, that trust can be spitting income back to the grantor. So we've seen a lot of situations where maybe there's no children in the picture, or maybe your children are financially secure on their own. They don't need any money, or maybe it's a split thing where, hey, we have a one trust that's going to benefit the kids. We also are very charitably inclined. We want to benefit this charity, but not right now. We still need some income during life, but we want to leave a legacy for this charity at our death. Charitable remainder trust is a great way to do that. Get a tax deduction today for that, and then have income coming back for the rest of your life. Again, comment at the beginning, there's anything that's legal you can do with a trust. So there's a lot more than just that. But at just kind of dipping your toes into it, there's a great way to do some charitable planning with trusts. And it's a lot more than we have time to talk about here just today.
I think it's fair to say we could probably do about 15 different webinars on trusts.
I think that's a fair
But
comment. Yeah.
yeah, I would think big picture, anybody who we're working with, any of our clients should consider a trust. Doesn't
Yeah.
necessarily mean they need one, but it should be a conversation that they've had at some point with us, with an estate plan attorney, to just verify what they want to accomplish. So, Frank, as we wrap up, anything that you wanted to share with people, or any other, if you're bringing this conversation to the forefront for anyone, any kind of places to start, or any thoughts you want to conclude with?
I think just the constant evaluation of goals is a really good thing to do. And by constant, I don't mean every single day, but you start the process, you start thinking about what your goals are. We make a determination that a trust makes sense. We go through the process, we get the terms set the way that you want the terms set. You get your trustees and your backup trustees and your backup trustees all figured out. You get that all set up, sign the document, it's good to go. Don't forget, a couple years down the road, come back and reevaluate. Is that backup trustee still someone that you trust? Is that someone that you want doing this? Fast forward a couple more years from there, where are your kids at? Does it make sense to still have a trust in place for them? Have your goals changed? Have your desires changed? Have their needs changed? So just knowing that it's a constant process that just needs to be retouched on, again, not every day, but every few years, just every handful of years, come back and make sure that it still says what you want to say, that laws haven't changed, because I promise you laws are going to change. And like you just mentioned with the Secure Act that came through, and that was a sweeping change. And if you didn't update your estate plan, you may be looking at issues there. So just always keep it in the back of your mind every few years. Let's pull out that document again. Let's take a look. Let's read through it. Make sure it says what you want it to say, and then go from there.
Yeah, I agree. I couldn't say that better. I would also just end on, I think with trust planning, less is more. So, we could write in a ton of provisions in trusts. And, if my son does this, and he marries so and so, and they're still married, and they have 3 kids and their kids are living, like, we want to have a flow of money, but there is certain language which gives some flexibility to the trustees. So, I think less is more when you're controlling the money. We're talking about potentially 50, 60, 70 years from now, and how that money can be spent, maybe longer. I think less is more, and just to some point, uh, you're gone. Just whatever happens, it kind of happens. So I think what we've seen oftentimes is too much control. So
Yeah.
less is more. Get the right stuff in there, but provide some trust, for lack of a better word, to the fiduciaries that you name within your trust document. So With that, thank you everybody for joining us. There's a lot of material, so if you have any questions, our hope is just to kind of spur some thinking with these conversations. So if you have any questions or if there are any thoughts, if there's anything that comes to your mind, we're always here to chat. We're always here to review what your plan is, where you're going, and whatnot. Please don't hesitate to reach out.